In this module, we will discuss about the contract. So basically, the contract management or the Indian Contract Act, it came into the picture in 1872, which prescribes the law relating to the contract in India and is the key act for the regulating Indian contract law. This act is applicable to all the states of India, and based on these modules it's a vast chapter where variety of topics are involved. So while moving on to the topics, the contract. So basically a contract, we all know, it is a type of an agreement between two or more parties which will be administered by the law. So under the law, an agreement is the every promise and every set of the promises that forming the considerations of each other. So basically, an unlawful agreement is similar or same as a void agreement and is not enforced by law. So that's why the general principle of contract is an agreement enforceable under law to do or to abstain to do something in exchange for consideration. So for that contract, there are certain definitions involved there. So basically, the relation is related to the agreement, and that agreement shall be enforceable by the law. So, talking about the contract. So basically, what is a contract and what are the essentials of contract? So a contract, basically, it is the article that describes it from the 1872 addresses the meaning of contract, where the essential elements are the fundamental to the creation of a valid contract. It means a contract is an agreement between two parties that I've earlier told, which will be enforceable by the law. So, as per the Section 2H of the Indian Contract Act, an agreement enforceable by law is a contract. So, hence, contract is therefore an agreement whose objective is to establish a legal obligation, that is, the duty enforceable by the law. So from the definition, it is quite clear that the contract include two elements, namely an agreement and the legal obligation, that is the duty enforceable by the law. So now what is an agreement? So according to the section 2E, every promise and every set of promises forming the consideration for each other is an agreement. So that statement says that basically promise is an agreement. Whereas section 2b that defines promise means when the person to whom the proposal is made signifies his assent there. That is, the proposal is said to be accepted. Means a proposal, when accepted, it becomes only the promise. So that's why the agreement constitutes the several parts: promise, acceptance, considerations, competence, and free consent. So agreement is basically offer and acceptance. Whereas, considering that, the in simple words we can say that an agreement is made only when the party makes a proposal or an offer to the other party, and the other party also accepts the proposal. Okay. So, what are the differences in between the agreement and contract? So, contract as a whole, it lies on the part of agreement. Means in the contract there is the inclusion of an agreement as well as the legal obligation, whereas agreement is simply a part for that contract. So the motto is an agreement is an understanding or arrangement reached between two or more parties, where a contract is a specific type of agreement. By its terms and elements is legally binding and enforceable in the court of law. So earlier I have told the section 2E is there and section 2B is there. So related to that, there are offers and acceptance. So that I have told, agreement is basically the linkage or the sum of offer and acceptance. So whenever, like, the definition means the number of persons are involved there. So as one person cannot make an agreement with himself if there is a need of two or more than other persons to make an agreement. So, an agreement can be made only when both parties accept the subject matter of the agreement in the same sense or in the same way at the same time. So, there are different types of contract, and not only different type of contract, so there are different nature of contract also. So basically, that the other part, that is the legal obligation. So an agreement can become a contract only when it results into the legal obligation. So legal obligation means any duty enforceable by the law. So the different types of contract or the different essentials in the contract. So this includes that the adhesion contract, the bilateral contract, unilateral contract, express contract, implied contract, void and voidable contract, quasi contracts. So a variety of contracts exist, but among them, the contract are classified based on the validity, its formation, and performance. So for that contract law, so there are the certain considerations. Means for this consideration, if I would say an example like suppose Mr. X, he agrees to sell his land at 3 lakhs to Mr. Y. So in this example, we can say Mr. X promised to pay rupees 3 lakhs in the consideration. So, what happens here that one party, Mr. X, he agrees to sell his land at 3 lakh rupees to Mr. Y. So, what happens? Mr. Y will have to pay. So, Mr. Y promised to pay rupees 3 lakh in the consideration for the promise of Mr. X to sell the land. So, in this case, the agreement becomes a valid agreement. So, that is under the lawful consideration. Like there are certain legal relationships cases also, just like a father promises his son to buy a bicycle if he gets first class marks. Many times many of you have observed such things, or personally also you have feel that your father or mother promised you that if you score good results, then they will give you certain things, gifts or like that. But the father here does not do so and fails to fulfill the agreement due to some reasons. Maybe monetary issue, maybe personal reasons, or maybe in some other cases. So in this case, the son cannot sue against his father as there was no legal obligation. So, case to case, this considerations varies because here comes the purpose to establish the legal relationship. So what are the kinds of contract? So that I have told that the contract is basically related to the three major categories: the validity, formation, and performance. So under these considerations, so there are the different types, that is the valid contract, voidable contract, the void contract, and the unenforceable contract. So basically, what is void contract, voidable contract, and these are the unenforceable and some are illegal contract also. So void contract means it is not enforceable by law. whereas the voidable contract are enforceable by law at the option of one party but not at the option of others. Whereas in illegal contract, no court will entertain or enforce the illegal contract. So basically, a void contract is a valid contract until the contradictory situation occurs. Whereas the voidable contract, these are valid contracts, and the illegal contracts are actually void contracts with broader scopes. So, giving you an example for the three different kind of that contracts. So, just like if I talk about the void contract. So, void contract means it is basically a contract where, just like the void contract say, the contract to import goods from Pakistan becomes void when a war breaks out between the importing country and the exporting country, that is India and Pakistan. So here, what does the law says? A contract becomes void when it ceases to be enforceable by law. So a contract when actually entered into by both the parties may be valid or binding on the parties. Then that means it says that a contract to import goods from another country is a valid contract. But if war break out between the two countries, the contract becomes a void contract. Then voidable contract. So for the voidable contract means suppose Mr. Y promises to sell his bike to Mr. X for the sum of 50,000. So here the consent is there through the force of the question. Therefore, the contract is said to be voidable contract at the option of the Mr. Y. He may avoid the contract or he is not elected to be bound by it. So the contract becomes voidable in the certain cases. What are the cases? If a person promises to do something for another person for a consideration, but the other person prevents him to do so, then the contract becomes a voidable contract at his option. But the other case, when a party to the contract promises to perform an obligation within the particular time, so any failure on his part to carry out his obligation, whether fixed time, makes the contract voidable at the option of the promisee. So, in short, that I have told, say, suppose that if one agrees to sell his bike, so his consent is obtained by use of force. So, the contract is voidable, which means if Mr. Y chooses, he may stand by the contract or avoid the contract. Now, the unenforceable law or the illegal contract law. So here, on that cases, the illegal agreement that occurs or that unenforceable contract under these cases. So basically, suppose one man borrows 10,000 from another one and enters into a contract with an alliance to import illegal goods. So what happens? Like, say, two persons here, Mr. X and Mr. Y. So Mr. Y knows the purpose of loan. So the transaction becomes a collateral transaction between Mr. X and Mr. Y for the principal agreement. So what is that agreement here? The agreement is an illegal agreement. Since the principal agreement or the original agreement is illegal, so when the original contract is void, so basically Mr. X entered into a void agreement with the minor. So here what happens that there are not even with the case of illegal good also. Just like suppose Mr. X rents B's house, Y's house to store some, say, smuggled goods. It's not always the importing. It's someone uses another house to store some smuggled goods. So the friend is aware of his purpose. So Mr. Y knows what is the purpose of A while using his house. So the agreement between that X and Y is a collateral to the agreement of buying smuggled goods. So this agreement is also illegal since the main agreement is illegal here. Then, based on the formation, I have told that what are the contract types: the express contract, implied contract, and the quasi contract. Contract. So, in this every type of contract, so according to the performance, also there are certain contracts, executed contract. Here, all the obligations are fulfilled, and nothing needs to be done. Executory contract are their contract, like some obligations are done and some are left. Then there is also an important part, that is the breach of contract. So every contract is, that is dependent on whether, say, offer or acceptance or its validity. So there are certain considerations also there. So under such considerations, there is a possibility of the breach of contract. So that is the failure to perform what a party is under a duty to perform. So that means basically that under this breach, that when this happens, like the non-breaching party can choose one or more remedies for the act. So, what are the remedies for the breach of contract? So, there are damages or monetary compensation also. So, basically, breach of contract under such circumstances or remedies, basically, this occurs when one party in the agreement fails to deliver according to the terms of the agreement. So then the breach occurred. Means a violation of any of the agreed upon terms and conditions under the binding contract, bidding contract. So here to breach means basically to break a rule or an agreement. So breach of contract means failing to do something as according to the contract. Then there are certain types of damages also here, like compensatory, consequential, then to punish and deter wrongdoing, to recognize wrongdoing also. So here basically these damages which are awarded for the breach of contract. So that nominal damages, that some nominal damages may be awarded when there is no actual proof that any loss has occurred due to the breach of contract. Whereas the compensatory damages, it shows like when these are awarded to reimburse the non-breaching party for any losses incurred as a result of the breach. So there are some that these damages have to be, there are the breaches that are related to, whether some are minor related, some are materialistic breaches, some are anticipatory breaches. So this damages or that breach, that is as a part of the monetary compensation also. So under this act, there are certain laws. So which are, that is just earlier I have told that as per the contract law, several essential elements are required. So breach basically that I'm talking about, that when any obligation involved in a contract is broken, there is a breach occurs. So here also, that for a valid contract, what are, as a summary level, if I would say, the key ones include the offer and acceptance. So there must be a clear, ambiguous offer made by and corresponding acceptance by the other party. Then consideration, there must be a valid and legal consideration exchanged between the parties. The consideration can be something of like the value like money, goods, services, or any promise to do to refrain from doing something. Then the competency of the parties, it involves the entering the contract must be legally competent to understand and agree to its terms. So that means the age restriction, like the minors and pupils with unsound minds generally cannot enter into a binding contract. Within contract, so the free consent is there, the consent for the both parties. Then some lawful objects are also included. That includes the object or purpose of the contract that must be lawful and not against the public policy or morality. So, as a whole, these are the several essential elements for the valid contract formation. So, some case studies I will share with you. Just like, suppose a company enters into a contract with a supplier for raw materials. However, the company's representative signing the contract did not have the proper authorization. So it comes under which category? Means you have to, suppose we have to analyze, one have to analyze the case, the potential consequences of this scenario based on the concept of capacity to contract. So under this Indian Contract Act 1872, it outlines the requirements of valid contract. So that in the consequences include the, like what is a void contract. One have to know that if a company can provide that the representative lacked the authority to sign the contract, so the contract may be declared void from the beginning itself. So this means it would be treated as if it never existed, and neither party would have any obligations under it. So the other parties, the voidable contract. So the company may be able to avoid the contract if they can show that the representative did not have the authority to sign and supplier knew or should have known about the lack of authorship. So in this case, the company have the option to either accept or to reject it. So, what recommendations can be done here? That the companies should have a clear internal procedure for in place for authorizing representatives to sign the contract. The contract should be reviewed carefully before being signed to ensure that the signatory had the proper authority. The suppliers can mitigate their risk by requesting written proof of representative authority to sign contract. So here, in this case, it is vital to know that who has the authority to sign or not. So under that circumstances, a contract is considered to be as a void, a voidable, or maybe an illegal one. Then another case, a company issues a request for proposal for a construction project. So several companies submit proposal there. So can the company arbitrarily reject all the proposals and reissue the request for proposal? So here the involved includes that I've earlier told in the initially the offer and acceptance. So here the request for proposal is generally not considered a firm offer from the company. It is basically an invitation to the interested parties to submit their proposal to their offer. So company often has the right to reject any of the proposal. So this basically includes the limitations of there are certain companies' freedom, a good faith. The proposal signifies the exceedance of the budget. the proposal where did not meet the minimum technical requirements. So there should be a transparency. So if company decides to reject all the proposals and reissue the request for proposal, it's good practice to be transparent with the bidders. So they can explain the reason for rejection and revise the request for proposal. So here the recommendations can be given like the document request for proposal. It should clearly state the company's right to reject any or all proposals. Although it's an under the Lawyable Act, but that contract should be mentioned there. So a company basically should outline the evaluation criteria for selecting the proposal. So if the company suppose decides to reject all the proposal, it's beneficial to communicate the reasons to the bidders. So where if they are having any intention to reissue the RPF, RFP, sorry. So basically, when the companies have the right to reject all the proposals, they should do so in good faith and with transparency to avoid further legal challenges or damage relationship, a broken relationship with the bidders. So another case study based on the breach of contract, based on the specific concepts we have gained from the topic. So a company issues a tender document for the supply of equipment. The tender specifies a specific evaluation criteria for selecting the winning bid. However, the company decides to award the contract to a bidder who did not meet all the criteria. So, what is the potential legal ramifications of this decision? Basically, there comes the breach of contract. So, the tender document, it is considered a form of contract between the company and the bidder. So, by specifying the criterias and deviating from it, the company may be seen as breaching his contract. So, he cannot decide to avoid the contract to a bidder who did not meet the criterias. So there is the issue for unfairness and challenge from other bidders. So other bidders who meet the criteria may feel unfair, untreated, and they also potentially challenge the award decision. So they might argue that the company did not follow a transparent or fair policy, and this leads to the legal action or complaints to the regulatory bodies. There is a risk of, say, for that unsuitable equipment means if the bidder does not meet all the technical or quality requirements in the criteria, the company might receive unsuitable equipment. So this could result in performance issues, safety hazard, additional cost, maintenance cost, maybe the supply of equipment can leads to further the death or casualties for the workers there in the site. So the decision. So if the company is challenged, what will be there? So they would need to justify the decision to award the contract to a non-competent bidder. So it is very difficult for them to demonstrate, but the non-compliant bidder offered significant superior equipment or some much lower prices. So there must be a justification. So there are unforeseen circumstances also that made the originally specified criteria impractical. So the recommendation related to that, to minimize that legal risk, the company should follow a transparent and well documented process. If the company decides to deviate from the established criteria, they should clearly document the justification for do. So there is the re-evaluating all the bids based on the revised criteria. So that case you have mostly observed in movies or in some practical cases nearby to your who are working in the construction industry. That one's relative is there or under some recommendation the bid has been given to some other parties without having the non-compliance. Many times I have seen near my home that the construction issues and are happening, that a worst company is doing the construction there, which does not have a proper good facility, proper good background, but he is having some relationships with the higher authorities, maybe some ministers, maybe some agencies. So that's why he have got that tender. So but the company, they are also, without having any fear of that challenge unfairness, they breach the contract. So under this module, we are having this variety of that contract, their issues, their topics. In the next module, we will start with the another phase.